Trump Trials and Presidential Election Daily Digest, February 5, 2024. Hello and welcome back to News Media Hant's Daily Digest. Chutkan contemplates prolonged Trump trial into 2024. In a recent conference for a separate criminal case, U.S. District Judge Tanya Chutkan provided significant insight into the potential timeline of Donald Trump's federal trial, acknowledging the possibility of its extension deep into 2024. The judge, who has been presiding over the case since December, explicitly stated her intention to be out of the country in early August, unless Trump's trial is underway. With a clear reference to the former president's case, she remarked, "I hope not to be in the country on August 5th, adding that her presence would only be stateside if she is involved in a trial unrelated to Trump's that has not yet returned to her calendar. Chutkan's acknowledgement marks the first public recognition that Trump's trial, centered on charges related to his attempts to subvert the 2020 election, could surpass key political events such as the GOP nominating contest and the Republican National Convention scheduled for July 15 to 18. Despite this revelation, Chutkan reiterated her limited control over the schedule, emphasizing that higher court's resolution of the immunity issue is crucial for the trial to proceed. In light of the canceled March 4 trial date, Chutkan has also scheduled a separate January 6 related trial to commence on that day, with additional January 6 related proceedings scheduled for April 2 and a sentencing on April 10. As she navigates this complex legal terrain, Chutkan maintains her commitment to a fair and expedited resolution, emphasizing the weightiness and urgency of the charges against Trump. Nikki Haley requests Secret Service protection amid threats. In response to a surge in threats, Nikki Haley's presidential campaign has officially requested a protective detail from the U.S. Secret Service, as confirmed by a spokesperson for the former UN ambassador. Haley revealed the gravity of the situation in an interview with the Wall Street Journal, citing multiple issues that prompted her campaign to seek the security measures provided by the Secret Service. The urgency of her request follows two swatting incidents targeting Haley's home on Kiowa Island in South Carolina, where police responded to fake reports of gun violence and threats of self-harm on both December 30 and January 1. Fortunately, Haley was not present during either incident, but the disturbing events have prompted her to take proactive measures to ensure her safety. The Secretary of Homeland Security, by law, holds the authority to designate major presidential and vice presidential candidates for Secret Service protection, taking into account various factors such as threats against the candidate, polling statistics, and the candidate's status as the de facto nominee of a major party. Reflecting on the threats, Haley affirmed her commitment to public service, acknowledging the reality of dealing with such challenges. She stated, "Part of running for public life is that you're going to deal with the threats that are there. Does it mean we have to put a few more bodies around us? Yes, that's fine. But at the end of the day, we're going to go out there and touch every hand." As the former governor of South Carolina, Haley's call for heightened security underscores the escalating risks faced by politicians in the current political climate. How criminal trials can heavily impact Trump 2024 run. Constitutional constraints and the 14th Amendment dilemma. Donald Trump's quest for the Republican presidential nomination faces an unprecedented challenge as he contends with 4 criminal indictments that could impact his 2024 re-election bid. Despite strong early victories and a frontrunner position, Trump's legal woes include accusations of mishandling classified government files, falsifying business documents, and conspiring to overturn the 2020 election results in Georgia. With the constitutional right for a convicted individual to run for president, experts are closely monitoring a potential disqualification under the 14th Amendment's disqualification clause. As 2 states, Colorado and Maine, have removed Trump's name from their primary ballots by citing this clause, the Supreme Court's decision on this matter remains pivotal. Scheduling challenges and political calendar alignment. The trials could pose scheduling challenges for Trump, requiring his presence in court, but the timing remains uncertain due to ongoing motions to delay or dismiss. Appeals have already impacted one case, postponing Trump's federal election interference trial originally set for March 4. As the political calendar unfolds with ongoing state primaries and the looming Super Tuesday, the trials could significantly affect Trump's campaign strategy. Republican Party rules lack a mechanism to remove a confirmed nominee, placing Trump on the ballot even if convicted. However, the trial's impact on public perception, as indicated by polls showing mixed sentiments among voters, raises questions about the overall electoral consequences for the former president. The Trump strategy, turning legal woes into campaign fuel. As Trump navigates the legal labyrinth, questions arise about the potential influence of criminal trials on his election chances. Despite facing 4 indictments and a base overwhelmingly supportive, Trump's strategy of leveraging legal challenges to energize his supporters could backfire among more moderate Republicans, independents, and undecided voters. While the criminal trials may not prevent Trump from securing the GOP nomination or appearing on the ballot, they present an opportunity for critics to highlight what they perceive as the former president's worst qualities. As the legal drama unfolds, Trump's ability to appeal beyond his core base remains a critical factor in the evolving narrative of the 2024 election landscape. The Constitutional Conundrum: Interpreting Section 3 of the 14th Amendment. Trump's bold assertion and historical precedent. Donald Trump's legal battle to secure his ballot eligibility hinges on a contentious interpretation of Section 3 of the 14th Amendment, raising fundamental questions about presidential accountability and constitutional intent. Trump's attorney, Jonathan Mitchell, asserts that the disqualification clause does not encompass presidents, invoking a strict textual reading of the Constitution. However, historians argue that such an interpretation disregards the framers' intent in safeguarding the nation against insurrectionist leaders, notably exemplified by the case of Jefferson Davis. As a group of American historians contends, Congress conducted an investigation into conditions in the South and determined that the disqualification of officeholders who had engaged in an insurrection against the Constitution was necessary for the security of the Republic. Clashing perspectives and legal complexity. The impending Supreme Court review of Trump's ballot eligibility underscores the clash between competing interpretations of Section 3 and its historical underpinnings. While Trump and his allies advocate for a narrow textual approach, emphasizing hierarchical distinctions within the Constitution's language, dissenting voices, including former attorneys general and conservative jurists, challenge this reading. They argue that the framers' primary concern was to prevent insurrectionist influences from permeating all levels of government, including the presidency. Amidst these divergent perspectives, the court faces the daunting task of reconciling textualist principles with broader constitutional imperatives, setting the stage for a landmark decision with far-reaching implications for American democracy. Implications and nationwide ramifications. The outcome of Trump's legal battle extends beyond individual candidacy to the foundational principles of democratic governance and constitutional interpretation. As the Supreme Court prepares to render its verdict, the nation anticipates a watershed moment that will shape the electoral landscape for years to come. With dozens of states grappling with similar ballot eligibility challenges, the court's decision holds the key to determining the future of insurrectionist presidents and the integrity of the electoral process nationwide. In this pivotal juncture of constitutional scrutiny, the judiciary confronts the formidable task of balancing legal precedent with contemporary exigencies, reaffirming the enduring relevance of constitutional principles in safeguarding democracy against existential threats. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.